After a DWI arrest in Texas, most families focus on getting the person out of jail. But the arrest may start two separate processes. The criminal case moves through the court and bail system, while the driver's license issue can move through the Texas Administrative License Revocation Program, commonly called ALR. Getting released from jail does not resolve the license process, and requesting a license hearing does not resolve the criminal charge. A person can be home, waiting for the first court date, while a separate administrative deadline is already running. That distinction matters to anyone who drives for work, operates a company vehicle, or depends on a license to support a family. Save this video if a driver's license is also part of the household income. The first clock is the one families can see, the jail release process. Posting bond begins that process, but it does not make the door open immediately. Jail staff still verify the bond, confirm the correct defendant and case, check for other warrants or holds, return personal property, and complete discharge paperwork. A family may hear that the bond was posted and assume a delay means something went wrong. Often, the jail is still completing required steps. Timing can vary between El Paso and smaller West Texas counties, especially at night, on weekends, or during busy periods. The practical response is to stay reachable and ask what stage the release has reached, rather than assuming the bond failed. Share this with the family member waiting outside the jail and expecting an instant release. While the family watches that first clock, the second one may already be moving. The Texas Administrative License Revocation process is civil and separate from the criminal DWI case. It can apply when a driver arrested for DWI refuses or fails a breath or blood test. The driver may receive paperwork explaining a proposed suspension and the right to request a hearing. Texas DPS states that an ALR hearing request generally must be made within 15 days after the person is served with the notice. Blood test cases can involve a later DPS notice, so the actual document and the date it was received matter. The first criminal court date may be weeks away, but the license deadline can arrive much sooner. Save every page from the arrest and ask a qualified DWI attorney about the license deadline immediately. That paperwork also matters because a driver may leave jail without the plastic license they had before the arrest. They may receive a document that serves as a temporary permit under stated conditions. This creates two common mistakes. Some people assume they cannot drive at all, while others assume they can drive normally until the criminal case ends. Neither assumption should replace the written notice. The person should read the effective dates, follow the instructions, and verify the current license status. Freedom bail bonds can help with the bond and release process, but a bail company does not conduct the ALR hearing or determine what driving privileges remain. Share this with anyone treating the temporary paperwork like an unimportant property receipt. The reason these deadlines matter so much is that, for many West Texans, the fastest consequence of a DWI arrest is not a courtroom result. It is a work problem. A commercial driver, oil field employee, delivery driver, service member, or company vehicle operator may face employer reporting rules, license requirements, or work restrictions before the criminal case is resolved. An arrest is not a conviction, and no video can predict what an employer or licensing authority will do. But ignoring a notice, missing an administrative deadline, or violating a release condition can make the employment problem worse. Preserve the documents and quickly identify which questions belong with the lawyer, employer, licensing agency, or bond company. Send this to the family member focused on release, but forgetting that the person's paycheck may depend on the next deadline. Employment is not the only part of daily life that can change after release. A DWI bond may include conditions that continue long after the person leaves jail. Depending on the facts and the court's order, those conditions can involve no alcohol testing, travel limits, vehicle restrictions, or an ignition interlock device. A first DWI, prior DWI, reported alcohol concentration, accident, child passenger, or refusal can create different concerns. Two cases that sound similar in conversation may have very different release rules. The signed conditions, not what happened to a friend, control the individual case. Missing a test or ignoring an interlock requirement can create a new bond problem while the original case is still pending. Follow freedom bail bonds for clear explanations about the bond rules that matter after release, not only on the night of arrest. The best way to manage both clocks is to separate the family's tasks. First, confirm the jail, charge, bail amount, and any other holds. Second, preserve the DPS notice, temporary driving paperwork, bond conditions, property receipt, and court information. Third, contact qualified legal counsel promptly about the criminal case and ALR process. Fourth, review any employer, military, CDL, or licensing requirements that may apply. This approach does not guarantee an outcome, but it helps prevent the family from watching one deadline while missing another. As a reminder, this is general Texas bail information, not legal advice. Freedom can help with the bail and release portion throughout El Paso and its West Texas service area. For 24-hour bail help after a DWI arrest, call Freedom Bail Bonds at 915-265-5650.